Hello all, this is Abhilash. So today I am going to start with the your subject of business law. Okay, so first thing is about the Indian Contract Act 1872. So let's start with the history. What is the Indian Contract Act? So the Indian Contract Act is one of the oldest mercantile law of our country. It came into effect on the 1st September 1872 and is applicable to the whole of India with the exception of Jammu and Kashmir. Containing a total of 266 sections, it is the principal law regulating contracts in India. The Indian Contract Act occupies the most important place in the commercial law. Without Contract Act, it would have been difficult to carry on a trade or any other business activity and in employment law. So it is not only the business community which is concerned with the Contract Act, but it affects everybody. The objective of the Act is to ensure that the rights and obligations arising out of a contract are honored and that legal remedies are made available to those who are affected. So according to the Indian Contract Act 1872 Section 1, this act may be called the Indian Contract Act. As per the Section 1, we can say that this contract is a Indian Contract Act 1872. So these are the divisions of Indian Contract Act 1872. General divisions of the Indian Contract Act. So section 1 to 75, the general principles of contract. From section 76 to 123 includes sales of goods. From section 124 to 147 deals with the contract of indemnity and guarantee. Sections from 148 to 181 is about contracts of bailment and pledge. Section from 182 to 238 is of agency and section 239 to 266 is of partnership act. So as per the curriculum, we have to get insights and details of section 1 to 100. So what is contract according to the Indian Contract Act? So Indian Contract Act frames and validates the contracts or agreement. So contract is in other terms we can say agreement. So Indian Contract Act frames and validates the contracts or agreements between various parties. Contract Act is one of the central law that regulate and oversees all the business wherever there is a case of a deal or an agreement. The following sections will tell us what is contract is. So we will see how the Indian Contract Act 1872 defines a contract. We will also define the terms as per the act and see what is that means. So in this topic we will see all the vivid aspects of the Contract Act. Let us begin by understanding the concept of contract. So from here we will understand what is the contract, white contract, whiteable contract and everything and their essentials in details. So as per the act, so section 2H of the Indian Contract Act 1872 defines the term contract as agreement which is enforceable by law is a contract. So whichever agreement which is enforceable by law is called a contract. So we can say that a contract is an agreement between two or more parties to do or abstain. So contract basically happen between and it's made up between the two parties, two or more parties. Basically, a contract is an agreement enforceable by law, and the agreements are not enforceable by law are not called the contract, or that is not a contract. So an agreement means a promise or a set of promises forming consideration for each other. So we will learn in depth what is a contract means to us in upcoming slides. Okay, so and a promise arises when a proposal is accepted. So by implications, an agreement is an accepted proposal. In other words, an agreement consists of an offer and its acceptance. So basically we know that what is a contract. It's basically an agreement between two or more parties. So one party offers some things to other party, and the next party, the other party, that if they are accepting the agreement, so that is called a contract. So basically we can say that there is offer and acceptance. So what is the agreement? An agreement is a valid when one party makes a proposal or offer to the other party signifies his assent. The following are required for a valid agreement. The agreement must be between two persons. Okay, this is one of the important point. The agreement will not happen in one, will not happen for one person. Okay, so it should be, agreement should be between two or more parties. So it is also required to be between an offerer and offer free. So who accepts the offerers becomes an acceptor, and both these parties should be different persons, as one cannot enter into an agreement with himself. As I told you, the contract must be between two or more parties. So it cannot enter into agreement with one person or himself. So both the offerer and offeree in the same sense at the same time should understand the agreement. So both should read everything, whatever the points, the things has been covered in the contract, or they have some forms, some rules. Okay. So enforceability. So after reading this word, what you are getting in your mind? Okay. So enforceability means the contract enforced by the law. So an agreement to mature into a contract must create a legal obligation as per the provision of contract laws, that is a duty enforceable by law. Right. So an agreement which does not create an enforceability, that is where the parties do not have a right to approach the court by a law to avail legal remedy for breach of contract, will not be contract. Understand? So here what the point is, the any agreement which does not create an enforceability. Okay, so the contract is not enforceable by law, and that is where the parties do not have a right to approach the court of law to avail a legal remedy or breach of contract, will not be a contract. Okay, the agreement which is not enforceable by law, where the parties will not have a right to approach the court if they are facing, if the contract is breached, right? So this was the basic about the agreement, offer and acceptance, and we have covered the what is the Indian Contract Act, right? So in my next session we will I will cover the different types of contract: white contract, voidable contract, and valid contracts. Okay, so thank you so much here. Thank you.